Hi everyone, my name is Margaret and I'm a paralegal here at Tsang and Associates, and today I will be sharing 10 things that I think you should know if you get an I-601 request for evidence. So the first thing that we tell our clients is not to panic. This is not a denial, it's simply a notice saying that they need more information from you. Some attorneys think that these are used for training purposes or even that USCIS is buying themselves more time to process your case. The second thing is that it's important that you don't just resubmit the same documents from your initial filing. You can submit updated documents. So for example, if you argued extreme medical hardship and your condition has worsened, then you can submit a letter from your doctor or other medical documents to show this. But overall, you want to take this out as an opportunity to improve your case and to convince the officer to ultimately approve your case. The third thing that you should know is that they only give you 30 days to respond. So essentially, you kind of have to be ready to drop everything to focus on this part of your life. So if you have an attorney, just make sure you get in contact with them as soon as possible so you guys have an agreement as to how you are going to work on this case and meet that deadline. The fourth thing is to make sure that you provide supporting documents for the claims that you're making. Sometimes there are people who think that they can just include the argument or include a letter with the argument, but that alone is usually not convincing or strong enough. So if using the medical hardship example, if you're claiming that you have a certain condition, then providing that letter or a supporting document would be helpful. Or in the example that you're suffering from sort of extreme emotional hardship, then you may want to show the therapy sessions that you've attended to sort of support this claim and make your case even stronger. The fifth thing that you can consider is supplementing your response with a psychological evaluation. Usually when we respond to a request for evidence, we include updated documents from the initial filing if they still support the arguments that we're making. And then we also sometimes we'll include a psychological evaluation, and then we include letters from the people who previously wrote one, or if there's other people who can support them. So it's a combination of basically updated documents, new documents, and also evaluating the case to see if there's anything new that we can present to build their case. The next thing to be mindful of is to make sure that you read the RFE completely and thoroughly and to address all of the prompts. Again, sometimes it's easy to get confused or to get lost in all of the language, especially because they use like the same language over and over and they paste big chunks of law onto the letter. But just make sure you that you read everything, but then you look for specifically what are they asking you to get and that you don't leave anything incomplete. For these cases, the burden of responding and proving your case falls on you. So if you leave anything incomplete, they will not issue another request for evidence, and they can ultimately deny your case because you basically didn't do what they told you. The next thing that you should make sure of is to ensure that you're consistent with the response. So again, double checking that initial filing with your response. You don't want to present any arguments that are contradictory. If something has changed, that's okay, but you need to make sure that you're clearly explaining the differences so it doesn't diminish the credibility or that they don't think that you're basically just throwing anything and trying to see what sticks. The next thing, again, is to not leave anything open-ended. This may be, again, your last opportunity to respond. Usually in our experience, it's the RFE and then the decision that should hopefully be an approval. But again, they will, out of a courtesy, they may give you the RFE, but they won't issue a notice of intent to deny or yet another RFE. So you just want to make sure that all of the officers' doubts are addressed and that you're being very clear about what the extreme hardship is. For example, if you talked about a lot of the extreme hardship for your children who are all U.S. citizens, but the officer specifically wants to know the extreme hardship that the spouse, which is a qualifying relative, would suffer. And maybe you do include a few things about the qualifying relative, but you continue to focus on the children, then that's an example of you not fully addressing what the officer is saying that they want to see. The next thing is that you can include previous AAO decisions in your brief or your argument. Usually the AAO makes decisions based on USCIS final ruling and they evaluate different rules and laws. So even though USCIS is not required to abide by these rulings, sometimes they do take them into consideration. We personally like to include some of that research where we compare our clients' facts to the AAO decisions, and we present how there's similar scenarios and how this office basically ruled in their favor to support our claim that our clients would also suffer extreme hardship. So lastly, the good thing is that if you get an RFE, it means that someone is actively reviewing your case. And this is an opportunity to just strengthen it and then just pull through. And usually in our experience, we've received approvals within 2 months. So again, as a reminder, don't panic. Just make sure you do your best in responding. This is probably the most important thing for your future. So just give it the attention and care that it deserves. We wish you all the best of luck. And if you have any questions, feel free to reach out. Thank you. Take care.